This is Paul. Yeah. hmm I would say that any debt collection has to be an interested party.
Yeah.
hmm And to not be an interested party,
Yeah.
common law maintenance charge were crimes and torts, as were barratry. Vexatious litigation.
Pooch.
Mhm. This is generally no longer so, as the 19th century development of legal ethics tended to obviate the risk to the public.
Yeah.
Scandal Swanson will case, however, the principle were relevant to the contingent fee agreements between a lawyer and a client, and to assignment by a plaintiff of his rights in a lawsuit to someone with no connection to the case.
Yes.
Champertus contracts can still, depending on jurisdiction, be void for public policy or attract liability for cause.
Yeah.
Now, I'm just guessing. At the time of the destruction of the actual documents,
Yeah.
there was no longer any interest, power of attorney
Yes.
to represent the charge off
Yeah.
or the purchase of the actual debt that you were collecting on.
Mm.
You became a third party
Yeah.
at the time of destruction, and you've committed champerty.
Yeah.
Now, my thought is that I'm going to sue you
Yes.
and the United States
Yeah.
for allowing for a third party to be disinterested
Yeah.
without the legal interest that is obligated for garnishment of wages.
Yeah.
Now, I'm just looking through here, England and Wales.
Yes. Yes. Yes.
On Merchandising Service Ltd, UK Criminal and Civil Law, which Civil Crimes Act, Section 44 to Section 46, perverting the course of public justice, malicious prosecution, abuse of process law, Criminal Justice Act of 1967. You know, for all of those over there in the Commonwealth of Great Britain, why don't you get me all the garnishments?
Yes.
Power of attorney.
Yeah.
The individuals known as the citizens of the United Kingdom.
Yeah.
I'm thinking, I could show the oh Now, destruction to me means that there can no longer be any interested parties in the actual garnishment or the collection of the debt.
Yeah.
That would mean that a third party, known as the same individuals that purchased it, that had the legal right to collect on it because of the purchase of it.
Yeah.
Let's see here. Concepts of Americans but to detain. A recent common usage term in media, Nevada, Ohio. Courts in Florida found the cause of action for maintenance champerty are no longer viable in Florida, but abusive process, malicious prosecution held that champerty and maintenance may continue to exist as affirmative defenses, but only as to enforceability of the champer's contract itself. Litigation funding, subpoena ad testificadum. Now, I just want to know right now, who's the idiot that said destruction isn't destruction and dismissal isn't dismissal? And for all the court rules that say that, well, I don't have to get any of the documentation because my Uncle Wayne.
Yeah.
I'd like to know where my genetics are, Bill and Melinda.
Pooch.
Now, somebody keeps choking me day after day after day.
Right now.
And I'm thinking that you're going through the actual DNA of individuals.
Yeah.
So for all the technology that
Right.
you have right now, I'd appreciate it.
Yeah.
If this idea that any individual can have an interest in any debt
Yep.
would be removed, and that when you purchase a debt or you represent the company that charged the debt off,
Yep.
it is for a length of time. And once it's destroyed or dismissed,
Yep.
or the statute of limitations has been reached,
Yep.
you are now a third party
Disinterested in the debt